Hill, would you like to address the committee?
Thank you. This is the bill that someone had passed a couple years ago. They exactly like it, and it never made it out of Judiciary A. And I got a call from leadership over there on that day, and they indicated to me that they would let this bill pass through if they did get over there. So what it does is just allows individuals that are transferred by officer after 21, and Alabama did it 20 years ago. Got involved. I just got a call last week from a representative in Louisiana, which works with a freshman legislator, and he's also an adopted person. He's 50 years old. He got to bill passed legislature.
And Senator, this is after the age of 21, right? There's an additional bill out there that we're not planning on taking up. They'll have 18. The plan is to bring up this bill and let the other one die. Is there any other concerns about that from the committee members? All right. As such, do we have a motion? Dr. Fish do pass. All in favor, say aye. Aye. Any opposed? All right, that'll be reported out. Thank you, Senator. Reported out to full committee. How about that? Senator England, I'm gonna make you wait just a minute on that one. Yours could have some questions. So Senator Seymour, let's go ahead and pull yours up while you're here. 2197.
Yes, this deals with the county veteran service officers. As you are aware, over the last 4 years, we have incrementally tried to increase their accreditation and responsibility. And one of the things now for the BSO officers is that they're able, when they're accredited fully and all, to represent veterans in the line of being an attorney, not a written power of attorney. So all this does is that they're acting in their full capacity and they're accredited, that they have that immunity of legal action.
All right, Senator, I've got a few questions on that. So tell us the problem that's going on out there right now. Are they contacting certain agencies and not being allowed to act or not being able to represent on behalf of that veteran? Is that what's going on?
Legally, they can't until they're fully accredited. I mean, it's an educational process I didn't realize that hadn't been in place for years. But as the officers are getting their certifications and all, one of their requirements is, that they be able to be the power of attorney to explain or more different issues for the veteran. So if the BSOs look at this, they're saying, what's my liability? And, they're concerned that they can be sued if they're doing their job and somebody feels that they didn't do it the right way.
Board, Senator Brady or Senator Wiggins?
Maybe I'm not understanding, but so line 58 written, it says written power of attorney. So if anybody has a written power of attorney, it's legally acceptable. So what's going on? Because we don't, I guess from a legal perspective, we don't need to put it into statute, because if somebody, let's just say if somebody comes to Senator Branning's office and asks for a power of attorney, she can drop a power of attorney and then it's legally valid. So what are we trying to accomplish?
This is to satisfy the mindset of the BSO officers, because they're not going to, they're going to rescind their job.
Who's saying that you cannot, they're not accepting a written power of attorney right now?
Harrison County, George County, Green, there's several of them that in their accreditation, they feel they don't have.
Have they gone to a lawyer to ask for a power of attorney?
These are not lawyers. None of these are, they're veterans and that are, they're hired by the counties in a 2 weeks out of the month in their.
So they're wanting to create like a form that says, I hereby have the power of attorney to act in this capacity.
All they're asking for is that in their capacity, whatever they do for the veteran, record, whether it be for the written power of attorney, that's what they're concerned about most. But in the.
They want to be able to act on behalf of the veteran.
Right.
Senator Brandon?
I think the issue goes deeper. Is it more the immunity issue? Because they can already act under a power of attorney presently.
They've got the ability to.
Right. So is it
Okay.
really the issue is that they're immune within those actions?
Yes, ma'am.
Well, would they have the ability to handle the finances of the veterans under a power of attorney? And if so, that causes me concern about veterans that may trust the local VSOs with all kind of matters, including financial matters. So has that been discussed?
Nothing on the financial end as far as, this is. The intent is that when they go before a board, say they got a disability or something to that effect, if the VSO is representing the veteran, then the veteran, the VSO is not, can't be sued for trying to do what's right for them.
Sure, and I certainly support what the VSOs do locally. I have a really good relationship with mine, but I think I'm looking at it from a different perspective. I have concern there's not any limitation in your language that says specifically on a disability matter. That might be all right, because I'm looking at the grander scheme of things. If we're talking about just a general power of attorney, that means that VSO can step into the shoes of that veteran and do anything that veteran can do for himself or herself, including banking matters, possibly medical decisions. There's a whole gamut of things. So I would just ask that if this concept continues to work through the process, and I'm not against the concept, I would just like to see some parameters placed really to protect the veterans, to make sure that there's not a rogue VSO somewhere that would take advantage of someone, and then there's nothing that you can do about it because of the immunity language in the bill. So that would just be my concern.
I would entertain anything, y'all. This is y'all's expertise. I'm out of my realm with this, and the chairman.
Well, Senator Seymour, I guess my question would be, it's kind of out of my realm. I don't work in this area. These VSOs are there for a reason. So we would actually need a little guidance from you as to what they're going for. Is it going to be through for the VA? Is it through, the state veterans? Just kind of a guidance on what agencies we're talking about that they need the authority to act on behalf of.
Just what you said.
So just
Through
before the,
VA, through, issue with them is the biggest part.
so that's the biggest part. Senator, let me ask you this, if I were to entertain a motion to table this, could you get some language before our next subcommittee meeting?
I will, Mr. Chairman.
All right, do I have a motion?
So moved.
So the motion is to table and to get additional language and bring it back up.
Tables, the motion, table subject to call of the chair.
Subject to call of the chair. All right,
Thank you.
all in favor?
Aye.
Aye.
Yeah.
Go Rusty. All right, so England, are you ready?
I'm ready.
Not after seeing that, he's not. Yeah.
2090 will be the bill number. Let's call that one up.
Yeah, thank you, Mr. Chairman. Am I recognized?
You are recognized.
Thank you. And I haven't had coffee yet, so if I get peppered with questions, I just want to go ahead and give you guys that warning. So section 731158, what that section does currently, it allows or it provides for a listing of individuals when a decedent has not left a written directive of how whether they should be cremated or the disposition of their body. This provides the heirs and who is next in line to make the decision on the disposition of the body. So that's already in the law. What this bill does is it states that the provisions of this section should not apply or do not apply to any individual that has been finally adjudicated by a court as being at fault in the death of the individual. So it removes them from that provision. And you'll see that I have a section A there, that if there's a process, you make a motion with the Chancery Court to designate the next person available. And if there's a criminal prosecution going on, this provides for the process of where the chancellor may require a bond. Of course, if the person is not found at fault, that bond could be used for reinterment or whatever is necessary. This is a bill that this is the first year I've dropped this bill. I found it was interesting when it came to me from a local attorney that has had to deal with this twice in the last 2 years with family members that were dealing with the death of a loved one, grieving, and the disposition of the body was left to the person who was at fault in the death of the individual. And he said this is just really tough on his clients, and he said this was a good idea. I told him I thought it was a good idea, and let's put it before the legislature and see if we can get this changed.
All right, Senator Wiggins.
Thanks for saying where you got it. So I'm glad the Lieutenant Governor's office is here, because I filed a bill at the request. This is a problem going on in the state, not just locally, which is why at the request of the state funeral board, they asked for a similar bill, which I filed and somehow ended up in one of the other committees. So and that bill is more comprehensive. So so we're trying to accomplish that, and I think it's a good bill. I think this is doing what that other bill is doing, amongst other things, and the state funeral board has said this is a huge problem, that it's not just going on here, it's going on in the rest of the state.
Yeah.
And that we need to get this addressed, because people come in and they fight over how to dispose of the body and where that needs to go, and it's putting our funeral directors in a big problem. So that's my comment, and I don't think there's any changes, but maybe we can combine it with the other bill.
Yes, sir. I think
Is it in Judge A as well? Is it in a different Judge A?
Interestingly, it's not.
So do you?
It's in public health or something.
Would you like to proceed with this one, or do you want to wait on that one, Mr. Chairman?
I say we proceed with this one.
All right.
But
yeah, thank you, Senator Wiggins. Thank you for comments. I think that's a good idea, and I look forward to having you sign on to this bill, and maybe we can get maybe we can look at some language, maybe a committee.
maybe you
substitution.
can sign on to my bill.
I will certainly do that. I'll be glad to do that. But
Senator
thank you for
Brandon,
the
do you have
comments.
Questions? So I do have a few questions, and we kind of mentioned some of this. So this process could get lengthy in the way that it's set up, go before the chancellor, and then there are a lot of times when you're not going to know who the person at fault is, because the investigation likely is only ongoing. That first 48 on television doesn't exactly solve the crime. So are you concerned in any way that maybe by the time that this arises, we're beyond the issue then? We've already got the person interred?
Well, I think that's a very good question, and of course, it does take a while sometimes to finally adjudicate through the process. But that's where the motion to the Chancery Court, I think, is helpful when there is a criminal proceeding ongoing. And that's why I allowed for a bond in that process, to allow for the chancellor to do as they see fit. And of course, you may end up with a position where a situation where you may have a reinterment, on down the line. But yeah, I think that's a very good question.
Right. Any other questions from the committee? Do I have a motion?
Title sufficient do pass.
Title sufficient do pass. All in favor, aye?
Aye.
Any opposed? Right.
Thank you,
it'll be
committee.
reported to the full committee. Senator England, thank you. 2153 is a transportation issue. Senator Wiggins, it's yours. I have a white sheet here on this. Would you like to present it?
Yeah, just briefly, this is coming to us from one of the rental car agencies in the state. And the bottom line is this, is it's a transparency bill, and it's simply requiring that rental car agencies put forward all the charges that they are charging consumers when they do it. There are hidden charges. There's been issues in some other states, and this is creating a level playing field for all of the rental car agencies. And it's about and it's also so agencies cannot hide charges, or like when you sign up and they, whatever it is, $100, and then they add on 27,000 different charges that you don't know about. That's what this is doing.
Senator Bragg, any questions on that? We actually have a individual.
Okay.
Would you like to address that issue?
Yeah, exactly. So, as currently written, this would create a statute within the Consumer Protection Act. And so I presume non-conform.
What he said.
Any other questions? All right, entertain a motion.
I
Vital sufficient do pass. All in favor, say aye. Aye. Any opposed? No opposition there. Lastly is going to be 2653, and that's one of mine. So it's pretty simple. In the wake of everything that we've seen going on over the last 5 years, this is a first step in saying, if you're a nonprofit and you receive more than $200,000 from the state of Mississippi, you simply have to submit a report yearly, annually, as to what you've done with the funds. Doesn't have to be detailed. It just has to be that we provided this program for this community, and this is what we did with funds. Unfortunately, my understanding is from the auditor's office that they pretty much have to have a complaint before they can acknowledge anything that's going on in a nonprofit when we send the money down the line. So this threshold is 200,000. If you think that's low, I have no problem with that. We can up it. But this is just a first step saying if we send you an appropriation of $200,000 or more, you submit a report that audit to the Secretary of State's office where those are housed under the nonprofit division. And then they're open to the public. So simple bill there. That is the intent, is to make this a little more transparent so we know where some of these funds are going. Any questions for me from the committee? Senator Brady?
Only the funds excess of 200,000 be reported. All of the funds itemized.
So it would be a general report. We're not asking for a total itemization of which individual received the funds, which we're just asking for a report. If you created a program for low income healthcare in the community and you receive those funds, you just got to say that that's what we provided the funds for. And then if there ever is a question, the auditor's office has that report, and from that report, they can proceed if there's a question as something was not used correctly. So. On that, but not sufficient do pass on that would be the motion. All in favor?
Aye.
Any opposed? All right. Lastly, last motion.
Rise and report.
Rise and report. Thank y'all all for being here. We stand adjourned.
No, we don't.